All right. Good afternoon, everyone, and welcome. My name is Brittany Mellinger, and I'm the Fair Housing Training and Outreach Coordinator at the Pennsylvania Human Relations Commission. And you're here in our monthly series, our Fair Housing and Power Hour series. And this month, we're going to be talking about tenant screening. Before we get started, I just wanted to let you know a couple of things. The first one is that we are recording this session, and the recording will be sent out along with the slides and resources that we discussed today. So you'll receive that within the next week after this presentation concludes. I'd like to thank our ASL interpreter today for helping us to make this program accessible. And I'd like to thank my colleague, Amanda Brothman, who's PHRC's Director of Communications, for providing technical assistance for the presentation today. So we always start out our fair housing presentations at PHRC by talking about how fair housing is the right of all Pennsylvanians. It's so critical to be able to access housing free from discrimination so that everyone has an equal shot at housing opportunities that meets their needs and all of the services and amenities that come with housing opportunities. I want to give you an overview of what we're going to be discussing today. We only have an hour together, but in that time, I hope to be able to provide you a very brief overview of the Pennsylvania Human Relations Commission for those of you who are joining our Fair Housing and Power Hour for the first time, just so you have an idea of who we are and what we do. We're going to be talking about our fair housing laws. We'll be discussing protected classes as well as discriminatory practices. And we're going to be spending the bulk of our time today talking about fair housing issues that can arise in the background check for tenants as they're navigating rental housing. We will provide an overview of the complaint process, and my goal is to be able to answer your fair housing questions as well. So I do have the chat pulled up. If you have any questions or comments or feedback throughout the presentation, please feel free to go ahead and put that in the chat. I will get to as many questions as I'm able throughout the course of the presentation, but I will also hold a few minutes at the end for any questions that you might have. And with that said, we're going to go ahead and get started. I'd also like to invite you to go ahead and say hello in the chat if you'd like to. It's always great to see who's joining us today and where they're joining us from. So please feel free to go ahead and say a quick hello if you are able to use the chat. So to provide you an overview of who the Pennsylvania Human Relations Commission is, we are the state's leading civil rights enforcement agency. We've been around since 1955. So this year we are marking our 70th anniversary. And we exist to make sure that Pennsylvanians can live, work, and learn free from unlawful discrimination. And we do that in our two-part mission. So first, we enforce our state's non-discrimination laws. And that includes both the Pennsylvania Human Relations Act as well as the Pennsylvania Fair Educational Opportunities Act. So these laws enable us to investigate complaints when they would come in. When individuals feel like they've experienced discrimination, they can contact our agency and have an investigator look into the situation. But beyond just responding to those issues when they come into our agency and when they're reported to us, we also work to actively promote equal opportunity for all in Pennsylvania. So we do that through trainings like this one. We offer this regular training series as well as trainings on demand in the fair housing space, as well as education, providing trainings on protections against harassment, a whole slew of trainings that you can find on our website. And we also hold events, and we've got advisory councils and social justice ambassadors, which are opportunities for community members to get involved in the work of the PHRC, sharing information about the rights and responsibilities that everyone has under our laws. And we also have a very active civil rights outreach division as well that provides a lot of events and resources to community members as well. We serve the entire state of Pennsylvania, and we do that through 3 regional offices. So we've got our Western region that's covered by our Pittsburgh regional office. We have The region in the middle part of the state, the central part of the state, up into the northeast, and that's covered by our Harrisburg Regional Office. And then the southeastern part of the state is covered by our Philadelphia Regional Office. I had mentioned our non-discrimination laws just a moment ago, and I want to let you know what those cover. So the Pennsylvania Human Relations Act, that really does a lot of the heavy lifting. So that covers employment, housing, commercial properties, public accommodations such as businesses and clubs that are open to the public, as well as local governmental services and things like that, as well as primary and secondary education up through high school. The Pennsylvania Fair Educational Opportunities Act extends that protection into post-secondary education. So colleges, trade schools, technical schools, and things like that. If you're interested, you can always check out our website, and we do have that link further on in the slide as well. But today we are going to be focusing primarily on our fair housing space. So we're going to start off by talking about our fair housing laws and what their goals are. So our first goal is ending housing discrimination, making sure that no one is kept out of housing opportunities based on their protected class. But fair housing goes beyond that. Our second goal is promoting diverse, inclusive communities. And we do that through affirmatively furthering fair housing, which is defined as taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities that are free from barriers that restrict access to opportunity based on protected characteristics. So we acknowledge that there have been a lot of unfair practices, laws, and policies that have existed in the past. And we have these fair housing protections now that have been put in place since then, but they've left these patterns of segregation and inequalities. So we've got a lot of active work that we need to do to make sure that we've got inclusive communities that are free from these barriers that would restrict access to housing opportunities. What do our fair housing laws cover? Well, they cover the sale and the rental of housing, as well as housing-related transactions. We're going to be focusing on the rental of housing, but I do want to acknowledge that that the sale of housing is covered as well as housing-related transactions, which could be anything from appraisals to insurance to mortgages, any industries that really surround the housing industry and marketplace and could impact someone's ability to be able to access housing. The types of housing are pretty broad, so anywhere from apartments to single-family homes, manufactured housing communities, condominiums, public housing, nursing homes, dormitories, and more. There's even some types of shelters that are covered by our fair housing laws. I want to touch on two discrimination theories or types of discrimination. So first we have disparate treatment. That's what a lot of folks think about when they might be thinking about what housing discrimination might look like. That's treatment that directly discriminates against a member of a protected class. So looking at the protected class of disability, that could be a person with a disability who goes to inquire about a unit, and the housing provider notices that individual's disability and thinks that the unit might not be safe for them. And so they deny them that housing opportunity and they say that it's no longer available. So they were denied housing because of their protected class. Disparate impact can be a little bit more subtle. So it's a policy that's neutral on its face. It doesn't mention any protected classes in the policy, but it does have that impact in having that substantial limitation, that disparate or that disproportionate impact on members of protected classes. So again, looking at individuals with disability, we could look at a screening policy that states that an employment to be able to qualify to rent a unit. That proportionate impact on limiting those housing opportunities, because we know that individuals with disabilities have a lower percentage of full-time employment than the general population. So it could have that impact on limiting those housing opportunities. We have several different layers of fair housing laws. So at the federal level, there's the Fair Housing Act of 1968, as well as Section 504 of the Rehabilitation Act of 1973, and the Americans with Disabilities Act of 1990. And those second two add on additional protections for individuals with disabilities. At the state level, there's the Pennsylvania Human Relations Act that forms the basis of our protections, as I've mentioned earlier. And then at the local level, you may have a local ordinance that provides even further protections. So the federal laws really provide the basis. And if we're looking at a housing analogy, we can look at that as the floor. There's the 7 protected classes, but our state protections build on those and add a few additional protected classes. And different localities throughout the state have added on additional protected classes as well. There are over 70 different ones throughout the state. So please do go ahead and look and see what might be available in your area so you're fully aware of all of your protections. I'd like to touch on jurisdiction really briefly, looking at which providers are covered that need to abide by our fair housing laws. Under our federal fair housing laws, it's housing providers with 4 or more properties unless they publicly advertise their vacancies or receive federal funding. If they advertising their vacancies, or if they do receive federal funds, they do need to comply with the Federal Fair Housing Act, regardless of the number of properties that they have. And it's a little bit simpler under our law. So it's housing providers with 1 or more properties. If you do believe that you've experienced discrimination, you want to file a complaint, it's important to know the filing timeline. So how long you have to be able to file a complaint. We know that when housing discrimination may occur, someone might not be in a position to go ahead and immediately file a complaint, particularly if they need to find new housing or stabilize their housing or address the issue at hand. So they do have some time to be able to file. Under the federal law, they have up to 365 days or a year from the date of the last harm. At the state level, they have 180 days, about 6 months from the date of the last harm to be able to file. Now, my next slide will show a couple lists of protected classes, but before I advance to that, I'd like to invite you to pull up your chat box and to put in any examples of protected classes that you're familiar with. Would anyone like to venture a guess as to any of either the federal or the state protected classes? Let's see, I see in the chat religion, absolutely. That is an example of a protected class. Are there any others that folks are familiar with? Gender identity, that is covered under the protected class of sex, which I'll cover in just a minute. Sex, race, and color and race, religion, absolutely. Age, yes, 40 and above, that's covered as well. National origin, disability. They're on a roll. Mental status is covered under disability. Yeah, absolutely. And familial status. All right, you guys did a great job. Let me pull up our protected classes so we can discuss a little bit further. So on the left-hand side of the screen, you can see here the protected classes that exist at the federal level under the Fair Housing Act. So you can see there are protections for individuals based on their race, their color, their national origin, their familial status, their religion, their sex, and their disability. And you can see on the right-hand side of the screen here, under the Pennsylvania Human Relations Act, we do mirror those 7 protected classes, although ours is termed religious creed instead of religion, but we add on to that age 40 and above, ancestry, as well as the use, handling, or training of support animals for disability. So our state law is a little bit broader than the Federal Fair Housing Act. I want to touch briefly on a few protected classes before we move on further. So first, familial status, that is defined as families with children under the age of 18 who are living with their parents or legal custodians. That does include people who are pregnant, as well as people who are securing custody of children under the age of 18. And that does include foster children as well, not just biological children. I also want to touch on sex as a protected class under our state statute. So you didn't see LGBTQ listed, or sexual orientation or gender identity under our list of protected classes, but we did finalize regulations in 2023 that established the definition for the term of sex. And those regulations state that sex may refer to pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, as well as differences in sex development. So we use these regulations as we accept complaints, conduct investigations, and adjudicate cases. If you're looking to learn more, there's a link at the bottom of the screen that will take you to the information that we have on our website. We also have an excellent fact sheet that's on our website that I do encourage you to share. I know that there have been changes at the federal level in the way that they do look at sex as a protected class, but I do want to affirm that if anyone believes that they've experienced housing discrimination based on their sexual orientation, their gender identity, any of these aspects of the protected class of sex, they can file with our agency and have their complaint investigated. The last protected class that I want to touch on is the protected class of disability, and that's defined as a physical or a mental impairment that substantially limits one or more of a person's major life activities. So some examples include caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. So it's not an exhaustive list, but that's just some examples of how someone's disability may substantially limit one or more areas of their life. So our fair housing laws offer protections to those who have a disability, those who have a history of a disability, as well as those who are regarded as having a disability. So it's possible that that a housing provider or someone else who's making housing decisions would regard someone as having a disability or would have knowledge of their previous history of having a disability and treat someone differently in their housing, whether it's denying them housing, offering different terms and conditions for their housing, and our fair housing laws do extend protections to those aspects of disability as well. Now, there are some exemptions that I want to highlight. So individuals who are currently using illegal drugs or controlled substances would be exempted from disability-related protections. Now, this does not include those who are in active recovery. So if someone is in active recovery, they would have protections under the protected class of disability. And individuals who pose a direct threat to the health and safety of others are also exempt from disability-related protections as well. So that's kind of the general overview of our fair housing laws to give you an idea and to level set for those of you who this might be your first Fair Housing and Power Hour that you're on. If you participated in previous sessions, this is probably a great review as well. But the focus today on rental properties and what that screening process looks like. I wanted to start off our discussion with just a quick overview on some complaint statistics. And this is
Please bear with us. It looks like we've lost Brittany. So just patient as we figure out these technical issues.
if you can still hear me, to put a message in the chat.
We can hear you now.
Oh, excellent. Thank you so much. So as I was mentioning, the National Fair Housing Alliance puts out an annual Fair Housing Trend Report, which discusses fair housing statistics nationwide. And each year, you can see that that complaints in rental housing are significantly more than any other type of discrimination complaints. So in the last year of data that's been compiled and reported, they comprised over 83% of reported complaints. And you can see that percentage increased year over year. Now, of course, we do see discrimination in other types of transactions, such as real estate sales, mortgage lending, homeowners insurance.
Brittany, you seem to be frozen again.
Okay, I apologize for any connectivity issues, and I'm hopeful that these will resolve shortly. I will keep on moving. So we can see a number of different fair housing issues and fair housing complaints that have to deal with rental housing, anywhere from discriminatory statements, whether in advertising or in conversations with housing providers, discriminatory inquiries, so inquiries asking about people's protected classes as they're seeking to obtain rental housing, being denied the ability to rent housing, being subject to unfair terms or conditions, whether that's in the lease or the policies of a housing provider, being provided facilities and services unequally. So that could be anywhere from being restricted from being able to use certain parts of the facilities, or being given poor maintenance services, delayed maintenance services, things like that. Being sexually harassed in your housing, or even experiencing harassment on the basis of any of those other protected classes that we covered as well as failure to provide reasonable accommodations and modifications in housing. But we are going to be talking specifically about the rental screening portion of the housing process with rental housing, since that's where we see a lot of denials of housing. So as tenants are exploring the unit, assessing whether the rental unit will be the right fit for their household, housing providers are also making an assessment to see whether someone is going to be able to effectively be able to pay the rent, stay for the full length of their lease, communicate effectively, keep up that property in good condition, and live peacefully with their neighbors, whether they can be a good tenant and a reliable tenant. So they do a rental screening, and that looks different from property owner to property owner to property manager to leasing agent. But typically they will look at a rental history or a history of evictions. They will screen for someone's involvement in the criminal justice system. Often they'll look at someone's credit history, their income, and their references, really trying to get at whether someone is going to be able to be a good tenant in that rental housing. So I want to start off this discussion with a little bit of additional information, first looking at criminal history. So approximately a third of American adults do have some type of record, and that is actually over 70 million different individuals. So most of us have a neighbor, a friend, or a family member that does have something on their record. Now, we know that 30 to 50% of individuals on parole don't have a stable home, and individuals without affordable housing are much more likely to recidivate. So housing is an incredibly protective factor in helping someone establish stability when they're returning from incarceration and seeking to rebuild their lives. According to a 2017 study, 90% of landlords do look at someone's record when they're considering tenancy, and they report ranking it as number 3 in importance, only behind income and eviction history. And that's based on a national survey. Another survey of reentrants found that 79% of respondents reported being ineligible or denied housing because of their records. Additionally, 1 in 10 reported family members who were being evicted when loved ones returned from incarceration. There was also a study in 2019 that found that even though there are all of these screenings that happen and that people are taking them into consideration, most types of criminal backgrounds, it doesn't actually increase negative housing outcomes. And after a time, a criminal background actually becomes insignificant. So looking at a misdemeanor, typically that's looking at about 2 years, and felony, that's about 5 years. So it's a really interesting study, and you can take a look at the link there on the screen as well. I want to also share some information on evictions. So if an eviction is filed against a tenant, it can appear on a search. So even if that eviction case does not end in a judgment against the tenant. So Governor Shapiro has proposed sealing eviction records, but there hasn't been any legislation passed at this point. And there's a link there if you want to learn more. And we do know that eviction rates are higher for Black and Latinx renters, as well as women, than the general population. And evictions on a tenant's record may prevent a tenant from being able to access high quality housing. I want to share some information on credit scores as well. So credit scores often do not capture information about payments that would indicate a lot of payments that indicate housing stability. So oftentimes a steady payment of rent, regular payment of utilities and other household bills are not reported back to credit agencies. So individuals would not necessarily have that opportunity to build that credit through those payments that indicate someone is a stable tenant. Additionally, credit scores often do not reflect payments that are made to payday lenders and other non-traditional lenders. We know that low credit scores and a lack of credit scores, as well as credit invisibility, are more likely to impact Black and Hispanic individuals, individuals with disabilities, and survivors of domestic violence who are predominantly women. So we can see that there's connections between protected classes and the likelihood of having these lower scores or credit invisibility that would prevent someone from being able to be approved for tenancy. So even though we're discussing all of these different factors, you can see that criminal history, eviction history, and credit history are not protected classes under the Fair Housing Act or under the Pennsylvania Human Relations Act. But there is potential for fair housing implications depending on the policies and the ways that these screenings are happening. So we see this in terms of disparate treatment, as well as disparate impact and refusal to make reasonable accommodations. So first, I want to touch on disparate treatment. So a housing provider may not intentionally discriminate based on protected class in the way they use the background for housing. So examples here, a housing provider runs a background check on Black applicants, but not on their white applicants. So they're using the screening as a way to treat people differently based on their protected class. A housing provider that's discouraging rental applicants that are Hispanic, that have a criminal record, but they're encouraging non-Hispanic applicants with a similar record to apply. And then lastly, a housing provider who's checking the eviction history of their female tenants, but not their male tenants. So there have to be these consistent policies and practices in place to make sure that people are not getting unfair treatment on the basis of their protected class. I want to refresh our participants' memory on disparate impact. So that policy has that discriminatory effect, even if it appears to be neutral. And some examples here, looking at criminal background. So a blanket ban that would deny everyone who has a criminal background has potential for disparate impact because of the ways that they limit housing opportunities for people of color. We're going to look at some stats here. So we know that people of color are overrepresented in the criminal justice system, both in Pennsylvania and in the United States. So according to some data from the Sentencing Project, Black individuals are 7.4 times more likely to be incarcerated than white individuals, and Latino individuals are 2.4 times more likely to be incarcerated than white individuals. That's in Pennsylvania. In the United States, Black individuals are 4.8 times more likely to be incarcerated than white individuals, and Latino individuals are 1.3 times more likely to be incarcerated than white individuals. And we know that that this overrepresentation is not because more crimes are being committed. It's because that there are disparities in policing, sentencing, and supervision, the way we implement our criminal justice system in the United States. So according to the Reducing Racial Inequality in Crime and Justice report, Black people are more likely to be stopped by police. They're more likely to experience use of force by police. Police officers treat Black people with less respect than individuals of other races, and Black criminal defendants are more likely to be detained pre-trial and convicted as a result. So looking at these inequalities in our criminal justice system, a policy that would exclude all applicants with a criminal record may have a disparate impact on Black and Latino applications. So looking at ways that we can prevent disparate impact, housing providers should use a screening framework that does allow for individualized assessment. So looking at criminal records, this assessment should look at the recency of the offense, the severity of the offense, as well as mitigating circumstances. And when we're looking at eviction histories, housing providers should assess the information that's being provided in that record. So if there's a record where a tenant prevailed, where a settlement was reached, or where the matter was dropped, that record should not be taken into consideration by that housing provider, even though that record comes up when it's searched. Because there was no judgment against the tenant, that shouldn't be considered. We know that there are a number of situations that may bring someone to an eviction hearing or to an eviction filing. There are often issues where a tenant might be asserting their rights to remedy housing concerns with how habitable and how livable their unit is. Oftentimes, there may be eviction due to a situation of domestic violence or where there was a sexual assault or stalking, and that should not be held against the tenant, even if it does appear on the record. For credit, housing providers should take into consideration other measures of financial stability and their ability to pay rent. So is there housing assistance that would guarantee a payment of rent? Or be responsive to changes in income? Is there a cosigner that could guarantee the rent? And was there an impact to that credit due to a situation of domestic violence or a medical crisis due to someone's disability? And a housing provider should communicate the process and the factors for assessments as they're looking at these various criteria clearly in writing to prospective tenants. So that way tenants know how they are likely to be how the housing provider assesses prospective tenants. And I want to touch on reasonable accommodations for individuals with disabilities. Individuals with a disability do have the right to request a reasonable accommodation that's needed for them to use and enjoy their housing. And when we're looking at reasonable accommodations, we're looking at changes in rules, policies, practices, or services. Reasonable modifications, on the other hand, which we talk a lot about in fair housing as well, that's when we're looking at changes to the actual unit, such as a grab bar or a ramp that would allow someone with a disability to be able to access the unit. But there are also times when we need to adjust the rules and policies to allow someone equal access to housing. So to determine whether a prospective tenant would qualify for a reasonable accommodation, a housing provider needs to establish several factors. So first of all, does that individual have a disability? Do they fall within that definition of disability, that substantial impact to one or more areas of life activities? And is there a disability-related need for the accommodation? Is there that connection between the disability as well as the need for that individual and what they're requesting? And is this reasonable? So what can this look like in terms of tenant screening? Reasonable accommodations related to someone's history may include waiving or altering screening policy, perhaps disregarding aspects of an individual's criminal history when determining acceptance into housing, or changing how much consideration is being given to an individual's credit history, and considering mitigating circumstances regarding an eviction. So you can see an example on the screen. A tenant with a history of substance abuse has minor offenses on their record that are related to the substance abuse. And the tenant has been sober and in recovery for 5 years. If we were in person in the room, I'd ask you to discuss amongst yourselves, should this reasonable accommodation be granted? And if you'd like, you are welcome to put your thoughts and assessment of that situation, given the information that I provided. But this request should be considered, and looking at those 3 criteria. Is this a person with disability? They are in recovery. Is there that connection with the disability and the disability-related need? So these minor offenses that are on their record are related to that substance abuse that happened in the past. And is it reasonable given that the tenant has been sober for 5 years? Lastly, in regards to reasonable accommodations, I want to mention a few exceptions as well. So some federally funded housing does have prohibition on certain offenses, including a lifetime sex offender registration and conviction of manufacturing or producing methamphetamine on federally assisted housing. And these offenses may not be waived through a reasonable accommodation request. Additionally, if an individual does demonstrate a direct health to the health and safety of others, a reasonable accommodation does not need to be granted. Now, if someone feels that they have not received fair treatment in their tenant screening, they are welcome to file a fair housing complaint with our agency. And there are a number of ways that they can contact us, either through our main line, which is 717-787-4410. They can reach out to their nearest regional office as well, and you can see all that contact information on the screen there. They can reach out through our main email, as well as go on our website for more information. We also do publish a lot of great information on our social media platforms as well. But they would reach out to first start with our intake team. So if someone believes that they have experienced housing discrimination, they would talk with one of our intake staff. So they'll be asked to fill out a housing questionnaire to provide their contact information, what they experienced, as well as who they are filing a complaint against. And then the intake team will assess this information to see if this is a situation that we can investigate under our state law. So is it jurisdictional and is it timely? Is there a protected class basis for this complaint? And then the intake team will help them to be able to finalize their complaint. And once that complaint is finalized and signed, then it's docketed and served, and the person who was filed against will be notified. And then it enters the investigative phase. So both parties will be asked to provide information to a neutral investigator who's responsible for investigating if there was a violation of our state law. So they might do that by asking for documents, interviewing witnesses, holding a fact-finding hearing where both parties come together either virtually or in person. They might go on site to a property or seek other ways of obtaining evidence. We do have mediation services here at PHRC, which are available for folks who have filed a complaint through our process, and depending on the facts of the case and depending on if both parties agree to mediation, which is a requirement to have mediation take place, that may be an option to more quickly resolve a complaint in a confidential manner. But the investigator will also explore if it's possible to settle a case before finding. If the case does proceed to a finding, there's two potential outcomes. It could be probable cause, so there was enough evidence to determine that discrimination did occur, or no probable cause, where there was not enough evidence to determine that discrimination did occur. If there was no probable cause, that's pretty much where the case ends. Someone can certainly file an appeal for that if they believe that we did not follow our process or did not consider all the information. But if a probable cause is found, the case does move forward. So it may be conciliated, it may advance to public hearing, or it may be filed in court. So at this point, our agency is no longer neutral. Our goal is to seek a remedy for the discrimination that occurred. And the amount of time that it does take to investigate a case really does vary. It depends on the evidence based on how quickly both parties respond, as well as other factors. There are a number of different remedies that can be achieved through the complaint process. So if someone was denied a reasonable accommodation or modification, that request can be granted, allowing that person to have access to their housing. There may be changes to the lease or other policies if there are discriminatory policies that are in place. That way, both the tenant that filed the complaint as well as other tenants at the property or other properties that are managed by that housing provider, now they all have fair leases and fair policies. There can be mandated postings of fair housing notices, as well as trainings for respondents. So making sure that housing providers have full access to information and quality training to make sure that they know what their fair housing responsibilities are and can avoid any future discriminatory practices. There can also be monetary remedies as well, either reimbursement of fees and out-of-pocket expenses, or money for humiliation and embarrassment, which is similar to pain and suffering. Now, this is only available in our fair housing and commercial property cases. This is not available in education and employment and public accommodations. Lastly, if a case does proceed to public hearing, there may be a civil penalty that's assessed as the cost of violating our state law. And you can see on the screen here some recent housing awards, anywhere from our top line number of $1.5 million in a case where a housing provider did fail to provide accessible units and ignored requests for reasonable accommodations for tenants with disabilities, $100,000 where a maintenance worker sexually harassed a female tenant, $90,000 where a housing provider revoked a lease and failed to address neighbor harassment based on race, or $77,000 where a housing provider made discriminatory statements and refused to rent to a household based on their familial status. So to loop back to some best practices on how to address screening. So for potential tenants, always recommend being honest about results that are going to be found on a background check. Know your fair housing rights, so that way you know your options. If you do need that reasonable accommodation request because of your disability, please make that request. And if you believe that you've received wrongful adverse action from a housing provider, if you were wrongfully denied that housing unit, you can contact the housing provider for more information. You do have rights through the Fair Credit Reporting Act to get information about the basis for that adverse action. If you have questions, please feel free to reach out to the PHRC. We do run a Pennsylvania Fair Housing line, which is 855-866-5718. You can call, talk with one of our trained staff to get some additional information and fair housing resources. And you do have a right to file a complaint if you do believe that you've experienced housing discrimination. For any housing providers that are on the call, if you do use a background screening, make sure that you've got a written policy that's available to all applicants, and make sure that your policy is based on reliable evidence. Is this an evidence-based practice that's necessary in order to do a screening for your potential tenants? I would encourage you to be cautious when using third-party screening companies to ensure that you know how they're going to be using data to make recommendations to you about accepting or denying potential tenants. There is a lot of potential for data to have bias in it, and that can have significant impact on individuals in protected classes. So you want to make sure that if you do use these third-party screenings, that you know what they're looking at, how they're looking at it, and how they're making recommendations to you. Definitely give the prospective tenant the opportunity to correct any inaccurate information that may pop up through a report, since that's pretty easy to have some inaccurate information, particularly if you have a really common name that can come up in terms of your credit, in terms of your eviction history, or your criminal background, and explain any mitigating circumstances to. And allow that tenant to explain mitigating circumstances regarding their background before you would make an adverse action against that tenant. Consider delaying consideration of criminal history until after other screening criteria have been applied. And ensure that your policy considers the nature, severity, and recency of any criminal conduct. Always be mindful of reasonable accommodation requests for potential tenants with disabilities, and conduct individualized assessments in clearly defined situations using staff who have received training in order to avoid bias. If you'd like to learn more, there's lots of great folks that are doing a lot of really great work and research in this area. So we've got a memo from our partners at HUD. We also have a fact sheet that you can access on our website. There's a digital toolkit from the Fair Housing Center for Rights and Research, which is in Ohio, but has some great information that's applicable nationwide. The Housing Alliance of Pennsylvania does a lot of great work around eviction prevention, and you can get a link to their resource library, as well as Eviction Lab is a great source of data. And there's a digital denials report, as well as information from the National Fair Housing Alliance on access to credit and algorithmic bias in housing and lending, if you'd like to learn more. Looking specifically at PHRC's resources, we've got the Fair Housing Line that I mentioned earlier, 855-866-5718. You can always reach out to request fair housing training and consultations. I'd be happy to get those set up for you. You can join us for future Fair Housing and Power Hours, or you can take a look at our archive on our YouTube. We have a variety of different topics that are available. We also have a variety of brochures and fact sheets that you can either download or request printed copies mailed to you. And we do have a show on PCN TV. It's called PHRC Speaks, Fair Housing Forward, where we explore a lot of the issues that surround housing and access to housing with the experts, advocates, and community leaders that are working to advance work in these spaces. And lastly, I want to point you towards our Fair Housing White Paper, which is called The State of Fair Housing in the Commonwealth of Pennsylvania. So we look at a lot of the data that really paints a picture of the housing needs in our state and how it impacts individuals in protected classes. I want to highlight that in just over a month, we are going to be having our 2025 Housing Equality Conference in Pittsburgh, and we would love for anyone who's able to travel to join us. I know we've got folks from all across the state on the call today, but please mark your calendar for this. We expect that registration will be open within the next week, and would love to have you be part of us, be part of this free event. All right, this is my last slide. It's got the contact information for our central office. It's got my email as well as our Fair Housing line on there. It also includes a QR code that you can use to take a quick feedback survey to share what you found helpful about this training, what you'd want for future trainings. It also will allow you to get on our mailing list, and you can also download a certificate of attendance using that QR code. But I will also send that out as a link along with the slides and recording, and you can take that survey later if you would like. So at this point, I'm going to take a look at the chat to see what questions may have arisen as part of the presentation. Let's see, I see if there was a question for a HUD tenant. Is there a different process for screening? So I assume that's a tenant that's either in, that's applying for public housing or for other types of subsidized housing that receives financial assistance from HUD, and they should all have a screening process that they have outlined, that they can tell you what factors they're going to be looking at in terms of background and what their screening criteria is and what tenants will be considered. I'm not seeing any other, okay, got some questions coming in, which is great. All right, there's a question regarding protections available in regards to housing screenings for survivors of domestic violence and sexual assaults and so on. So there are specific protections that are outlined in the VAWA, the Violence Against Women's Act. So that's a federal law that has protections that ensure fair screenings for folks who have experienced domestic violence and how that's how they're screened. But at the state level, we would look at that in terms of potential for disparate impact for women who form the majority of survivors of domestic violence. We know that while there certainly are individuals of all genders and sexualities that experience domestic violence, the majority are women, and so someone could file a complaint on the basis of sex if they felt like they weren't given a fair screening or fair policies. All right, I'm seeing another question here about receiving specialized financing and have pledged a certain percent of tenants coming from unstable housing situations who have incomes under a certain amount or who have special needs. Is it okay to screen for these things? I know for certain funding sources, they are directed at specific situations. But I would definitely take a look at your grant and your financing and the details on that, and make sure that your screening policies are also in compliance with the Fair Housing Act as well. It may be worthwhile consulting with your legal counsel just to make sure that that there aren't any policies that would have disparate impact against individuals in other protected classes. All right, that's all of the questions that I'm seeing at present. I will give it another minute to see if there's anyone else, but I'd like to thank everyone for their participation today. I'd like to thank our ISL interpreter providing the interpretation for today's session. I'd like to thank my colleague, Director Brothman, for providing technical assistance. And I do want to let you know that I will be sending out the recording as well as materials within the next few days, by early next week at the latest. If anyone has any additional questions, you'll have my contact information and you can feel free to reach out to me directly as well. Thank you again and enjoy the rest of your day.